roll. Looks like we have some minutes here. Do I have a recommendation from, or a motion from either Representative Roten or Coberly? Representative Roten.
Mr. Chairman, I've reviewed minutes from Wednesday, January 17th, and minutes from Friday, January 19th. Reviewing both of those, finding them in order, I move that we pass them as presented.
Seeing no lights, all those in favor of the motion indicate by saying aye. Aye. Any opposed? Motion carries. I'm going to take a personal privilege, as I do at each meeting, a little bit of what's coming up. My compliments to our IT department, who got things together very well for us as we got through our hearing on Friday. We were able to do that with pretty good accomplishment. If any errors that were there, there's on my part. As a reminder today, witnesses, or not witnesses today, but witnesses can only register in this committee electronically. We have a QR code at the back, and if you want to help somebody and you know how to register, you can just walk them down to the hall to the help desk, and they'll help them sign up to testify for our bills. So please remember that and pass that word around. The help garden desk down the rotunda is very good at helping people, and they help some people on Friday. And we discussed about some of our lobbying that went on in this bill last meeting, and over the weekend I've had all positive reports about our lobbyist behavior, so thank you very much. As a committee, we worked very hard thus far, and I'm grateful for each of your hard work. We've been here a couple of Fridays. It's my goal that we meet, or that we work hard early so we don't have to work hard late. And so, but there's a reward for me and you both. February 4th is a Friday. I'm planning not to meet on that day, so you can plan your private lives accordingly. And today we're going to finish up discussion of House Bill 406, and we may take a vote on motions made, if motions are made. And how we're going to finish that up is the presenters will come up and present however they decide they want to. I see both are here. And we're ready to go. So presenters, introduce yourselves and wrap up your thoughts on this bill, if you would.
Thank you, Mr. Chairman and members of the committee. Todd Lakey, State Senator from District 23. And I'll start, and then Representative Hill will conclude. So, Mr. Chairman and committee members, I think those that spoke in favor at the last hearing did a really good job of covering the points that support this bill, but I'll emphasize a few high points. And I said before at the hearing that Idaho is a great place to live and to raise a family. And part of the reason we are a great place to live and that people want to live here is because we've made strong, clear policy decisions that we are not going to make it easier for drug dealers to do business in Idaho. We have mandatory minimum sentences for those that are dealing or trafficking in dealer quantities of marijuana, meth, heroin, and cocaine. We have dealers that have refused to do business in Idaho, refused to come here because they're aware of those mandatory minimum sentences and they don't want those consequences. So this is a deterrent. Fentanyl is at least 100 times more dangerous, more lethal and deadly than heroin, and it's extremely addictive. And part of the reason we have fentanyl flooding into Idaho and taking the place of heroin and other drugs is because we have a gap in the fence. We don't have any mandatory minimum sentencing for fentanyl. We have it for meth, coke, and heroin. As you heard at the last hearing, fentanyl seizures have increased 2,638% from 2020 to 2023. For dealers in Idaho, it's safer for them to traffic in fentanyl than any other drug. I'm not saying and did not say that this will stop the flow of fentanyl in Idaho, but it will reduce the flood. Dealers will do less business in Idaho. It will save lives. We have to attack supply and demand. Certainly there is more need for treatment and counseling. Absolutely recognize that. But if you don't also hold the dealers accountable with harsh consequences and you're just saying people need treatment and counseling, you get the Portland, the Seattle, and the San Francisco model, which clearly don't work. So we have to attack supply and demand. Mr. Chairman, some organizations think that dangerous drugs are a victimless, nonviolent crime. The violence and property crimes that are associated with drugs are well documented. If you're selling a drug like fentanyl, you're creating addiction. You're ruining families. You're ruining lives. You're ruining jobs. You're putting kids in serious danger. You just as well break somebody's legs. Or in the case of fentanyl, you have a good chance that you'll take their life. I have more sympathy certainly for users, but not dealers. And there's no truthful examples of someone that's just a personal user being charged with trafficking under the other drugs. All have been proven to be dealers. And these are dealer quantities. There's no legitimate argument otherwise. The minimum tier, 100 to 250 pills, and up to 2,000 lethal doses at 4 grams. The quantities differ, but this bill has the same knowledge, knowingly language, the same mixture language that we have for our other drugs in our drug trafficking statutes. So this is not new language. In Idaho Code 372732B, we made the policy decision that if you knowingly have these larger dealer quantities of marijuana, meth, cocaine, or heroin, you're involved in trafficking or dealing. We make it harder with our trafficking statutes for drug dealers, not easier. And if you're manufacturing or moving these quantities, you are trafficking. The quantity, in essence, is your intent to be involved in dealing. I'll just briefly mention the same existing language that we have in code. In 372732B for cocaine, any person who is knowingly in possession of that amount of cocaine or any mixture or substance containing a detectable amount of cocaine. Meth, same language, knowingly in possession of meth or any mixture, same language. Heroin, knowingly in possession of heroin or any mixture, same language. We have to have the mixture language because that's what dealers do. They cut or they mix it with other powders so they can sell more. The prosecuting attorneys have checked this. 49 other states have the same mixture language. So it's the same language in this bill. It's necessary. It's not new. Our law enforcement and our courts are familiar with it. Please don't let extremely unrealistic examples distract you from the deadly reality of how drug dealers work and how we have to attack them. The example of marijuana laced with fentanyl. Our law enforcement is not seeing it. It seems to be a myth that's perpetuated in some of the stories that are put out there about the fentanyl crisis. Our law enforcement noted they haven't been seeing it. I talked to the state lab, they haven't seen it. They talked to their colleagues nationally, they haven't seen it. And as I visited with the state lab, they came up with a practical reason for this. Drug dealers are in the business of maximizing profits, pure and simple. That's what they're about. Marijuana is cheaper than fentanyl or other drugs. So you don't put more expensive fentanyl into marijuana, which sells for less. Marijuana is what it is. They don't disguise it. People buy it for different reasons, for a different high. But dealers make more money selling fentanyl by cutting it in a powder to sell it as fentanyl, or to sell it as oxycodone or cocaine or whatever it is they're lying to you about what the substance is. So the marijuana example is not reality. It's not a reason to get rid of the long-standing mixture language that's needed to attack how drug dealers actually do business. Lastly, the prosecutor has to show that the person knowingly possessed the fentanyl. So the person who truly didn't know, who borrowed the friend's car and didn't know about the fentanyl hidden in the car speaker box, is not guilty of trafficking. We have a gap in our fence, representatives, and that is the fence that helps protect us against cocaine, meth, and heroin. But fentanyl is pouring through that gap. 70% of the pills, as was testified, are potentially lethal. Our law enforcement community is united in asking for this. Our community leaders are asking for it. And 86% of Idahoans are saying we need this. Please send House Bill 406 to the floor with a due pass. Representative Hill.
Representative Hill, you have about 2 minutes.
All right, sir.
And then there'll be questions perhaps of both.
Okay, Representative Hill, Chairman, Representative Hill from District 14, it's Eagle and Emmett. I want to reiterate the distractions that we've seen in this are frustrating. I want us to refocus on the objectives of this bill, as we want to stop the scourge of fentanyl in this state. That's the objective. Defend Idaho against this threat. Talked about Idaho just passed a threshold as a hotspot alert for fentanyl overdoses. And that compared to Chicago, St. Louis, and Mississippi. They're coming here. The cartels see the opportunity, they see the vulnerability, and they're taking advantage of it. They're poised and ready to overwhelm us. Where they see weakness, they see opportunity, and they will continue. I have had enough of the cartels having what they say for me in my state. I'm tired of the cartels sabotaging our society, sabotaging everything we have in this state. Time to be proactive. Time is now. The bill will give law enforcement the tools they need to succeed. Decisiveness and strength are essential. Deterrence is real. Let's make that happen. If we choose not to pass this bill, we send a signal to the cartels that we're not serious. They will exploit us and they will take advantage. It's a slippery slope and will get worse. So we need to be strong and we need to pass this bill. Please pass House Bill 406.
All right, our presenters are open for questions. Representative Cannon.
Cannon or Cannon?
Oh, I get your lights mixed up. Representative Roten.
Okay. Mr. Chairman, for motion,
The motion is always in order.
I move that we send House Bill 406 to the floor with a due pass recommendation.
There's a motion on the floor. Representative Cannon,
For a substitute motion,
go ahead.
I move that we send House Bill 406 to the amending order, and I'd like to speak to my motion if I may.
You may.
Thank you. So we've heard a lot of testimony this year about this issue. We've actually, those of us who, well, all of us heard a lot of testimony about this issue last year as well. I feel like there are some things that we can improve in this bill. I feel like there are some concerns that those of us on the committee have that could be addressed through a number of amendments or an amendment. I want to, before I get into the merits of that, I want to make sure that we're all on the same page in terms of what I am trying to do with this motion. I am not trying to kill this bill. I do think that we can improve this bill. I made a similar motion last week and felt like the response was a response that impugned my motives. And I want to kind of speak up for myself in that regard and say that impugning of my motives, indicating that I was trying to kill this bill, was as incorrect as it was contrary to our House rules. I am not trying to kill this bill. I do feel like it can be improved. What would happen if we sent this bill to the amending order? If we send this bill to the amending order, anyone in the House who believes that they have a way to improve this bill could file an amendment to it. It would follow the same process by and large as RSs or other proposed pieces of legislation. At a given point in the session, we would meet as a body of the whole on the House floor to take up the amendments and to debate them briefly, 5 minutes on each side. It wouldn't go on indefinitely. It would be a proceeding that would have a start and a finish time, again, 5 minutes on each side per amendment. At the conclusion of that debate, the entire House would vote on each amendment. Then the resulting bill would be voted on by the House and continue through its course in terms of becoming law. So I want to make it clear that those people who have said, if we vote to send this to the amending order, we are killing this bill, that is not true. I am confident that a bill taking on fentanyl will emerge from the legislature this session. Furthermore, nothing will be amended on this bill unless it gets a majority vote from the House floor. So if there's some provision that 2 or 3 or 5 or 10 or 15 of us think might improve this bill, it's not going to get through. It will be defeated, and we will have a vote on the merits of the bill. If there are 36 of us in agreement on one particular amendment that we say this could be an improvement to this bill, we could vote for that, and we could then vote for the amended bill. This is what I think we should do. I'm not pretending that I have all the answers. I do have some concerns. I feel like they are legitimate concerns. Let me speak to those concerns at this point. One thing that I want to say that is that I'll just say off the cuff because I wasn't prepared for this, but I came into this hearing, and I think many of us did, believing that marijuana laced with fentanyl is a real thing. We heard testimony this year that it is a real thing. We haven't heard testimony at all that it's not a real thing. We have heard argument now from the bill sponsor saying that it is not a real thing. And to me, we ought to have an opportunity to flesh that out and learn whether or not it's a real thing before we send a bill to the House floor that potentially has a problem with it. Assuming that it is a real thing for a moment, let's consider the ramifications of that. Because of the language of this bill, which applies to any mixture containing any detectable amount of fentanyl, and because of the weight associated with fentanyl in this bill, 4 grams of marijuana, which are laced with fentanyl, would pull a possessor into the mandatory minimums that are set forth by this fentanyl trafficking bill. Furthermore, 1 ounce of marijuana laced with fentanyl would subject the possessor to the maximum amount of mandatory minimum prison time, 10 years. 1 ounce, I did a little research this morning, there are at least 25 states that allow legally recreational marijuana in their state, and every one of them would be, a 1 ounce of marijuana would be legal under their recreational marijuana statute. These are users. So if nothing else, let's change the language of the title of the bill and quit referring to it as fentanyl trafficking, because we are capturing in the net users, and we shouldn't be misleading about that fact. When my first session in the legislature was 3 years ago, and the big issue back then, at least in my mind, was balance of power type issues. And we had a number of things. It was right on the heels of the pandemic being declared an emergency, and a high percentage of the session was dedicated toward balancing powers in terms of the executive branch and the legislative branch and the judicial branch in dealing with emergencies that arise. Much of what we did was to undo bills that had become law from decades before, where the legislature had ceded its authority to the executive branch. And 3 years ago, we said, we've given too much authority to the executive branch. We need to take some of it back. And that was the big push of that session. In this case, we're dealing, in my view, with a balance of power and checks and balances issue. We are dealing with a fundamental right, liberty. We are dealing with a criminal justice system that is based on separation of powers, where every branch of government is involved. The executive branch, through its police force, sheriff's offices, and prosecutors' offices, enforces the law. Our branch, the legislative branch, makes the law. The judicial branch has a number of roles, including passing on constitutionality of the laws that we pass, but also in being involved in the trial process and in the sentencing process. There's another body that is involved that, because of the fundamental nature of the rights involved, adds an extra check and is sacred to American history, and that is the right of a jury to be a final check on what happens in the criminal justice system. This bill, if it does nothing else, and it might be a great bill and it might be needed, but before we send it to the floor as is, I want us to consider a couple of things that it does. One, it takes and reshuffles the deck as far as the balance of power and the checks and balances goes. It takes judicial discretion away from the judicial branch through our judges and vests that, in addition to the power that the executive branch has to enforce the law, it vests all of that discretion with the executive branch. Through this bill, if we pass this bill, the legislature will be ceding its authority to be involved in this process. We will be saying, hey, we're going to write a law, we're going to pass a law, and it's going to define certain people as fentanyl traffickers. Included in that definition of fentanyl traffickers that we are going to make would be somebody who possesses 4 grams of marijuana laced with fentanyl. Right now, if somebody is charged with fentanyl trafficking, and there is such a thing as fentanyl trafficking, the jury would weigh in on whether there is a requisite amount of what's called mens rea, criminal intent, on the part of the defendant. We would be saying we don't need a jury to determine that. Those of us in this room and those of us on the House floor and the Senate floor and the gentleman on the second floor, 106 of us can say anytime there is any detectable amount of fentanyl in any mixture that weighs at least 4 grams, we are saying that person has the intent to traffic in fentanyl. And that makes me extremely uncomfortable. Lastly, I think that the part of this bill that we didn't debate last year needs some thought and needs some debate, and we learned about it, I think, less than a week ago, and that is the death by dealer provision in Section 3 of this proposed law. I'm not saying that's a bad provision, but one thing that deeply concerns me is the point that we learned that this would apply automatically to juveniles 14 years of age and older. They would be treated as adults and be subject to the death by dealer type provisions in this law. So again, in conclusion, I am not trying to kill this bill. I 100% believe that there will be a bill that emerges from this legislative session that takes on fentanyl, and I even, believe it or not, could see myself supporting that bill in the end. But I have had a determination to try to not fall into the pitfalls that legislatures have done before in terms of unbalancing the balance of powers. We need checks and balances in our criminal justice system, and I think we ought to slow down a little bit and give people an opportunity to present amendments that might make this a better law, and then debate those, and then those that have the support of the majority of our body can be amended in, and if none are, then we can vote on this bill. But in any event, whatever emerges from that process, we can vote on, and I am very confident that we can pass that law. Thank you.
Representative Garner.
Yes, Chairman Skog, I would move that we amend the substitute motion to send House Bill 406 to the floor with no recommendation, and if I may speak to it.
Go ahead.
Members of the committee, we've heard a lot about fentanyl. You need to remember that 4 grams that has the ability to kill 2,000 individuals. So if they are caught with 4 grams, even if it is laced with another substance, there are still going to be Idahoans that die from this drug. To talk about that if someone's 14 years old and is dealing and might be charged under this thing, I think we all have common enough sense to know that we have 14-year-old gang members that deal drugs. Any deterrent we can use to keep fentanyl off of Idaho streets and save Idaho citizens is going to be a good thing. And I urge you to support this motion. Thank you, Chairman.
Representative Gannon.
Thank you, Mr. Chairman. There is new language in this bill, and it is in Section 3, and it is the drug-induced homicide language. And that is something that is a very serious change because it appears to make drug-induced homicide a first-degree murder, second-degree murder charge, according to the presentation from Jean Fisher, who I have a lot of respect for. She worked at the Idaho County Prosecutor's Office for over 30 years and was a pretty tough prosecutor, as I've heard it. I don't practice criminal law, but I've heard her name from time to time. The concern is this. If it's a first-degree murder charge and we don't have an intent provision in this statute in 37, 27, 32D, which is listed, then that is a departure from the idea of first-degree murder, and it's a very serious departure. The second concern is that it will apply to those under 18. And so I have a very serious concern about charging kids with first-degree murder for that reason, for the reason that they are immature and that I'm not sure, that I am very uncomfortable with putting them in a situation where they are punishable with up to, I believe, 99 years in prison for an indeterminate term of life. That's the language from the statute. So I think that there is a reasonable way to resolve the drug-induced homicide part, which is the part I'm interested in, and that is to make it manslaughter by having an amendment that makes it manslaughter. We take the 18-year-old or less and automatically out of the criminal system. They're in the juvenile system. And there may or may not be a process where if it is extraordinarily heinous what they did, that they could get back in the criminal system, as I understand it. But it's an unusual and extraordinary idea or move by the juvenile court system. The manslaughter charge would more closely coincide with the fact that there is a lack of intent in this statute, because manslaughter doesn't require the degree of proof or culpability, I should say, that first-degree murder does. And so it would be my thought that that this bill be sent to the amending order, and that one of the amendments that you would have to choose from would be solely dealing with the change of this new law from first-degree murder, from the effect of first-degree murder to manslaughter. And it would be one amendment that you would have a chance to vote on the House floor in order to make this bill more in accord with present law and the present way we address the very serious charge of first-degree murder and second-degree murder. If the bill were to go to the amending order, of course, there would possibly be other amendments, but it takes a majority vote of the members to approve or disapprove of other amendments. And so those who have concerns about particular provisions would be able to vote accordingly, and those who don't have concern would be able to vote accordingly. It would be my thought that at least one of the amendments, and I can pledge that at least one of the amendments will provide, because maybe I'll make it, will provide that the new legislation in Section 3 would become manslaughter instead of murder.
Representative Young, and then if you would indicate before you start if this is a question for presenters or you're commenting on the motions.
Thank you, Mr. Chairman. I was actually going to ask if I may ask a question of the presenter.
They'd probably be glad to get a question.
The good senator? Certainly. Thank you, Senator. I feel pretty strongly in this process that I like to leave the bill sponsors in control of a decision to send something to the amending order. If the bill sponsor would prefer to take their chances with the questions that may be out there and have the bill live or die, I prefer to respect that. If you have an openness or a willingness to consider an amendment, then I also would want to respect that. So I would welcome your comments.
Mr. Chairman and Representative Young, I don't think we would be in favor of going to the amending order. Either the initial motion or the third motion would be our preference.
Follow up?
Thank you. Mr. Chairman and Senator Lakey, could you speak to Representative's comments about parity in the murder section, specifically because we really haven't had very much time to vet that language?
Mr. Chairman and Representative Young, so murder is what they would call a waiver, automatic waiver offense for a juvenile, among some other violent crimes where they would be treated as an adult. Can you hear me? Let me try this. Is that better? Okay. So there are a list of violent offenses that, if committed by a juvenile, move them into the adult court system, where they have, the same due process rights, but they are treated in the adult system instead of the juvenile system. And homicide, murder, as I said, is one of those. As was discussed, there was some discussion from the prosecutors about that particular aspect of the bill. They look at the initial situation and determine whether or not that's an appropriate charge, whether homicide is appropriate. And frankly, I think this aspect of the bill would be difficult to prove as a prosecutor. That the fact that causation was there and that was the person that did it would be a challenge. But the prosecutor would look at those circumstances and determine whether homicide is appropriate or something less could be charged. It's the charging, the allegation that comes out, that's what brings it into whether it's homicide and then potentially the automatic waiver into the adult system. So I think again, it's appropriate. The substance we're dealing with is extremely lethal, and it's known to be lethal, but I think the circumstances surrounding a particular case in a juvenile would be addressed by the prosecutor and whether that was appropriate for homicide or something different.
Representative Alfieri.
Thank you, Mr. Chairman. I wondered if I might also ask the presenters to help clarify something that Representative Cannon brought forth. And Senator Lakey and Representative Hill. What I'm hearing is that a mixture of fentanyl in perhaps a tray of brownies or pot could be less than 4 grams, and we would still have a trafficking problem. Is that true? Because I'm seeing here any mixture of substance containing detectable amount of any such substance.
Mr. Chairman and Representative Alfieri, so as I mentioned, I think in hyper theory that's potentially there. We have the same mixture language that we have for cocaine, that we have for meth, and that we have for heroin. And we haven't heard or seen any examples of those substances being commingled with marijuana or stuck in brownies. I think that would be very difficult for the lab to test, very difficult to prove. What we're talking about here is trying to deal with a realistic example. And the lab confirmed they're not seeing it. Law enforcement confirmed that they're not seeing it. They would be reluctant to charge it. So it's not a realistic example. We have to have that mixture language because that's the way drug dealers put out their product. They mix the fentanyl powder with other powders to divide those small 2 milligrams that can be lethal into doses that they can actually sell on the street. They're not mixing it in brownies. They're not putting it in a can of Coke. They're not doing other things with it. They make their money by selling it as fentanyl or saying it's cocaine and selling it as cocaine, but not those examples.
Representative Scott.
Thank you, Mr. Chairman. Senator Lakey, I want to just make sure I understand this murder section. That's what I'm trying to figure out. And when I think of murder, I think of intent to kill. And when I read this language, and you're saying there's no examples, but what I envision is a kid with a pill that has fentanyl in it. He wouldn't be a trafficker, but he takes that pill and he grinds it up and he throws it in some brownies. Just kids do things like that, kind of like they swallow, I've seen them, laundry pods, it's a big fat or so. So they get some fentanyl pills, they put them in brownies, they share them, and as you talked about, the dosage of that, can be very concentrated in one part of that pill. So that one part of the pill hits one person, and one person that ate one of the brownies, all the kids split the brownies, that kid dies. Is the person who put that pill in those brownies, is that a life sentence for murder? And if it is, help me understand intent, because I can't understand, when I think of murder, I think somebody is actually going out there to murder, and I don't see somebody that shares drugs, not that I think that's a good thing, I don't see someone that shares drugs as an intent to kill their neighbor or their friend.
Mr. Chairman and Representative Scott, so there's a couple of, levels to that question. First level is that we are talking about fentanyl, and fentanyl is extremely lethal. Everybody knows that. So there's a heightened sensitivity to that lethality. when we're talking about fentanyl. And then I think the other level to that is I don't know that the lab could test for that and figure out what the quantity was. But I think, again, what we need to focus on is realistic situations where that could be charged, and we're not seeing those things, either in the state or nationally. And then the other level is, if we're talking about that situation, you have to prove that they violated the drug statutes, either possession with intent to deliver or the trafficking statute, and that person died as a result of that. So those are high burdens of proof there. But you also have the prosecutor looking at the situation and seeing what it was and whether that's appropriate to charge as homicide. As was discussed, there are multiple levels of homicide. First-degree murder is the one that carries the death penalty and has that specific intent, premeditation. You have others that's more of a reckless disregard for life, crimes of passion. This sentence does not carry that death penalty. It's a potential of up to a life sentence. So it's not that first-degree murder that you're talking about. And again, I think the prosecutor has to they would look at the situation, if that was even feasible, and determine in that particular case whether it was appropriate to charge that or something else with a juvenile.
I have a comment on this.
Go ahead.
I first learned of this when I did my, okay, this Chairman, Ted Hill. I'd like to talk to that, what Representative Scott had. When I was working down in LA, I worked with the Sheriff's Department and did some fentanyl work with them and saw how absolutely they were incapable of enforcing the law until the DEA came in. The DEA had certain laws. And the DEA I spoke to down there in LA, they had this law. They go specifically after the actual dealers that actually provided that. They're going at, they go up the chain, say, how do you do this? They go up the cell phone, they find the dealer. That's the person that has intent. That's the person they're going after. And the DEA does that now. They're doing it right now. And they go after those big guys. They go up the chain. They're not looking for what we said. That's distraction. That's not going to happen. But they go up the chain and find out he gave out 500 pills that went out. And they find a chain and they go get this guy. The DEA had 2 cases they showed me. That's kind of what we're looking at. Those specific dealers are really the intent. They're trying to actually distribute that.
I'm not sure who was first, so Representative Hill, or Allgood, excuse me.
Thank you, Mr. Chair. A couple of points. First of all, in 372734D, drug-induced homicide, there's no mention of murder, first-degree murder, second-degree murder. It simply says drug-induced homicide. And I believe that leaves the door open for a prosecutor to charge on a number of different levels. But more importantly, I have been in a number of leadership positions, decision-maker positions for a very long time in my life. Some of that period of time, I was making decisions that were literally life and death decisions. And no matter where I ended up being, including today, I have never assumed that I know everything. I have always been smart enough to surround myself with people who know what I need to know and can tell me. And we have been absolutely blessed to have experts from right here in Idaho, both police officers and city leaders and prosecutors that deal with this on a daily basis, come and tell us what they need. And I don't claim in any way to know what they know. And the fact that they were here and showed up and told us what they need and how they need it to work, to me, carries just a ton of weight, because I understand that I need advice from people that are there and know what they're doing. And so there's this discussion that, well, this bill is different from the bill we've had since 1992. Our experience from 1992 to present is our law enforcement officers and our prosecutors have done a very good job with this language to enforce our drug laws. there is no indication that we've ever had a problem with our drug law, our mandatory minimums, based on what we hear from our police officers and our prosecutors. There's theory, but these men and women that do this every day, they can tell us exactly how it works, and they have told us that it is working. And so my final comment is, I base my decisions on what I hear from the experts and what I've heard in the past week from our experts. Thank you.
Representative Cannon.
Thank you, Mr. Chairman. A question for the sponsors. I've heard you both say that that in essence we're going after traffickers and not users. Part of what I've learned both through my career and in the last 2 years that we've been dealing with this is that we have a really high incarceration rate in Idaho, including the highest incarceration rate per capita among females, and that a very high relative to the nation percentage of our inmates are there where the most serious offense they've committed is a drug offense. That would be hundreds, if not thousands, of inmates. Are those the dealers that you're talking about, or are we incarcerating in the state of Idaho end users as opposed to only dealers?
First thing I'll say about that, Mr. Chairman, I think it's really clear on who we're going after. I don't think the user ever fits into this. I've talked to the sheriff, and those numbers and how many people are actually in jail for actual drug offenses is like 3%. So I get some puzzling information. It's really not so. People are involved with violence and drugs and violence and other things, but just users themselves, 3% is what they're doing. So I think that's not accurate on terms of who's in jail. I think that we're not going after the user. I think that's kind of an excuse out of this. It's very clear. The thresholds are very high. The standards are very high to get there. I don't think we're going to ever get a user. We're going after that guy with the 10,000 pills. We got a guy down in L.A. when talking about this L.A. piece. We went to 10 different places at one time and busted them in. We went into one, had 50,000 pills in their house. That's the guys we're going after. That's who you're looking for. And that's the whole objective. All this other stuff, we're getting lost in the weeds on these distractions on users. Focus on what we're trying to do. We're going to keep people from dying. If we don't move on this, we're going to go lax on this. Hundreds of people are going to die from overdoses if we don't step into this decisively.
Mr. Chairman, Todd Lakey, State Senator from District 23. I would agree that the percentage of folks that are in prison for trafficking is relatively small. I don't remember the percentage off the top of my head, Representative Cannon. But again, there is a difference between dealers and traffickers, dealers and users. Personal users certainly can end up in prison because they tend to violate other laws. They may violate the terms of their probation. There's other crimes associated with that. But when we're talking about trafficking, we're talking about somebody that is engaged in what I very much describe as a violent crime, because they are ruining people's lives, they are killing people, they are putting children at risk, not of their own just personal safety, but there's examples of individuals trafficking their children to pay for their drug offense, their drug addiction. So dealing is very different than personal users. And those that are dealing should be put in prison because they're facilitating other people's use, and they're facilitating death, and they're facilitating basically ruining people's lives. So it is a violent offense, not a nonviolent offense. And it's appropriate that they should be put in prison. And again, I think that's why Idaho is a desirable place to live, because we take a strong stance on drug trafficking.
Representative Young.
Thank you, Mr. Chairman. If I may ask another question of the sponsor,
Certainly.
Senator Lakey. All right, thank you, Senator. I'm looking specifically at the language in the drug-induced homicide, and I'm wondering if, for the benefit of those of us who haven't worked in the judicial system, if you could explain to us on line 43 where it says, "for an indeterminate term of life," can you explain to us what that means and what it really looks like?
Mr. Chairman and Representative Young, this is one place where you have discretion for the court. The other instances have a mandatory minimum sentence. And that's the minimum. The judge can go higher for that based on the quantity. In regard to the drug-induced homicide, that's a maximum sentence. So the judge doesn't have to impose that. They can impose something less, something they deem that's more appropriate. So that's an indeterminate period that's up to the court to determine the sentence.
Chairman's going to take a privilege. So Senator Lakey, indeterminate can mean no jail time. Is that correct?
Mr. Chairman, I believe that's correct.
I'm watching. There we go. Representative Roten.
Mr. Chair, I really didn't have an opportunity to speak to my motion, and I would like to. We heard all the testimony. We went through this last session, so we've been through it. We've heard a lot, and we went Friday. We had 2.5, 3 hours of testimony again. We've all done our homework. I would assume that most of us, if not all of the folks here on the committee, have met with your law enforcement. They have pleaded for a tool to fight this. They pick these people up for possession, and they get kicked loose, and they're arresting the same people over and over. We're after the traffickers. The police and law enforcement have asked and asked, pleaded to have at least this tool, make it a mandatory minimum, which we already know works from what we already have on the books. Now you've got surveys from a number of places, some saying 86% of the population in Idaho, some of the numbers, you can fact check that, number check that, are in the same position, asking us to do something. Now they're, and that ranges with what they're asking to do. But we get this bill to the floor, we have 35 districts represented. We've got the 70 representatives representing those districts. I'm pretty sure the people in every district would like us to do something strong with regard to fentanyl. We've got the receipts now. As I understand, since last year, we lost 188 fentanyl-related deaths.
322.
We'll speak through the chair.
322. I know there were deaths, and said some narrowed that down just to fentanyl. Either way, 188, 322, anywhere in between, too many. We all know how dangerous this is. We all know that this has exploded and exponentially as far as what the police are seeing on the street that they're picking up. We know how dangerous it is. It doesn't discriminate. It can kill with a little bit. It can kill young. It can kill old. It can kill many. It doesn't care what color you are, how rich you are, as we've seen. It doesn't matter. This fentanyl is a bad deal. We have an opportunity here to do something that we know is killing Idahoans. Maybe we can't stop it, as they've testified to, but we can certainly do something to slow it, certainly give something to our law enforcement, all the branches, that give them a tool to help protect the good people of Idaho. We've got it in front of us. It's here. It's sitting there. It's been sitting there. You go back to physics. A body at rest will remain at rest unless acted upon by an outside force. We are that outside force. This is an opportunity for us to make that change. It's sitting right here, right in front of us. We've heard hours and hours here in this chamber. Many of us have heard hours and hours outside of this chamber. You've all gotten 1,000 emails, like I have. You know, some for, some against. But you've seen it all, and you hear the stories. Well, perhaps the jails are already full. Is that really a reason not to deter something like this? I think we'll find room. It's important to many out there. A number of these deaths are accidental. That's what this drug is doing. We're not able to close the borders. We're not able to control China that's making the mixtures with Mexico. We don't do nothing because we can only do a little. We do what we can. And this is what we can do. You've got it right in front of you. You can argue all you want. We cannot do anything. And this year it'll kill more. I can guarantee that. I'm pretty sure I can guarantee that. Up to us, up to you. I'm ready to vote. I know most of you are, but it's right here in front of us. Right here, right now. We get it to the floor, this is going to pass because the people of Idaho want this. Thank you.
Representative Ehart.
Mr. Chairman, more of a question. We have 3 motions before us. Would now be the appropriate time to speak if we want to speak to a different one, or, I'm kind of, or ask another question, I guess.
I'm opening this up. You want to speak with questions or ask questions, or you want to speak to the motions, either one?
Maybe I'll do both, but given that, Mr. Chairman, would the good chairman, Senator Lakey, stand for a question, please?
Mr. Chairman, Representative Ehart, certainly.
Awesome. Thank you, Mr. Chairman. Senator Lakey. First off, I am very appreciative, both of you now and Sheriff Donahue and others who are acknowledging that there's still going to be death. As I understand it, it's going to slow down. But that was just as on record, that's been incredibly frustrating to me to purport to say that if we pass this, that death ceases. It doesn't. It hasn't. But given Representative Young and some of those questions, would you mind addressing me, maybe help to ease my concern of the question I think I asked Gene Fisher, and I think you kind of, or maybe it was Representative Scott. So let me ask it my way. So if you have some high school kids, dumb high school, maybe even college kids, and they decide to play with some drugs and, school kid A says, hey, do you have the drugs? School kid, or do you have the connection? School kid B says, I think I do, but I don't have any money. And, D, C, D, F, G all says, oh no, we've got money, and they all donate. And then they say, and school kid D to go get the drugs. And then someone dies. And just to help me with this, and Section C, who's culpable, and who's culpable and who would be charged? And would it be, what would your, and I know you're not, but your best, help me out with that, please.
Mr. Chairman and Representative Ehart, I think Prosecutor Loeb's kind of attempted to answer that question and did about the best you can. It would be difficult to determine who was at fault if they were all kind of contributing and kicking in to get that. It could be all of them. It could depend on every case depends on the facts and circumstances. The other thing to think about is, the statute requires that they be guilty of that trafficking action. So if they're high school kids, they're typically not getting into the fentanyl. They're trying to buy Oxy or something else for their party. And if that's what they thought they were buying, and what they thought they had, then they're not involved in trafficking. So that would be difficult to prove. And then in those facts and circumstances, you have the prosecutor and the law enforcement looking at all of those things to determine, really, are we talking about somebody that was involved in seriously taking someone else's life? And that's, they appreciated that risk. And then ultimately, that portion of this legislation carries judicial discretion. So the judge would be the third party looking at that.
One last follow-up on that.
Follow-up.
Mr. Chairman, Senator Lakey, so that helps. And you're right. Mr. Lobes did address that. So my one other concern, and maybe kind of address this, is if a child dies, and even if they were culpable and going to help chip in and go get the drugs, the parents are going to want somebody to stand accountable. I'm certain that emotional input, I guess it's so hard to say, I recognize that. Maybe I'm just asking for hope that wouldn't necessarily ruin the lives of 10 other kids, because the parents want someone to be held accountable, even though their kid was involved. And even, Senator, even if they didn't help chip in and go get the drugs, the fact that they chose to use the drugs. Anyway, is there anything you can speak to that? And it's not exactly just, if you could, great. If not, I understand.
Mr. Chairman and Representative Ehart, so the facts and circumstances are what play into every case. And whether it's, somebody that hit somebody with their car, or, pick those circumstances where there's a lot of emotional tug to it. At the end of the day, it has to meet the criteria, and then at the end of the day, the prosecutor, the law enforcement look at the facts, and in regards to this one, the judge looks at the facts. So I think those things come into play at the various levels, all three.
Thank you. And Mr. Chairman, I'll wait until questions are done and then maybe make my own little statement, but I think there's some other questions here.
Committee, I'm writing down names in order of when I finally see the lights, and they may not be in the right order, but I'm going to have to put a little bit of a parameter on this. I'm going to go to anybody who has a question, and then anybody that's light is on currently, and then we'll get through the questions and release our presenters and get into any discussion on the motions. So anybody that, right now, turn on your light if you have a question of the presenters. Representative Gallagher.
Thank you, Mr. Chairman. This question is for Representative Hill. It is, you have been down to the border of Mexico.
Mr. Chairman, yes, I have. I visited Eagle Pass.
And do you believe that the open border situation and what is happening at the Mexican border is a contributing factor to the fentanyl problem that we have here?
Mr. Chairman, yes, absolutely.
Speak through the chair.
Mr. Chairman, for a follow-up.
Go ahead.
And do you, in your work and your travels and what you have seen on this issue, the precursors that are coming from China, do you believe that those are also coming through the open Mexican border?
Mr. Chairman, well, I know the precursors are coming from China. It goes into Mexico, and then they use those precursors to make the drugs. So that's the chain of what the Chinese are doing.
Mr. Chairman, can I just make a final statement? If this were to pass, if this legislation were to pass, I just want to caution our body that we need to be careful of any legislation that moving forward after this, if this passes, that invites more people to come across the border.
Further questions? Representative Garner?
Chairman Skog, this discussion would really benefit the full House, so I call the question, or I move question.
Okay. Been a motion calling for the question. Roll call has been requested by my good vice chair. So I'll follow up. The motion is call for the question, which means we will go to the vote immediately if this motion passes on the substitute, amended substitute motion. And I have been gently reminded to ask you to speak into your mics, please.
No more, no more. No, but then you should.
Go ahead.
Mr. Chairman,
Representative Gallagher.
we're unclear as to what exactly we are voting for at this moment. Can you please just give us the simple
Yes,
version of what we're voting on?
And that type of request is always welcome. We've been asked to call for the question, which means we're going to vote on the substitute amended motion, which is the last one, which came from Representative Garner, to send it to the floor. That's not what we're voting on now, but his motion was to send it to the floor without a recommendation. So, but this first vote is, should we stop all the questioning, stop all the talking, and get on with the vote? So if you vote yes, we're done with questions, we're done with discussion. And turn your lights on to vote because we're going roll call. Thank you.
Representative Skog,
Yes.
Representative Scott,
No.
Representative Ehart,
No.
Representative Young,
No.
Representative Cannon,
No.
Representative Erickson. No. Representative Alfieri,
No.
Representative Allgood,
Yes.
Representative Dixon, 24,
Yes.
Representative Gallagher,
No.
Representative Garner,
Yes.
Representative Handy,
No.
Representative Lambert,
No.
Representative Sauter,
Yes.
Representative Roten,
Yes.
Representative Gannon. No. Representative Coberly,
No.
Representative Matthias.
No.
The motion fails 6-12. The nays have it. So now we'll continue on with any questions of our presenters. And now I've forgotten the order. Representative Allgood.
Point of order
Yes.
or question, what was the vote?
6-12.
Okay, thank you.
Representative Allgood.
Mr. Chair, I didn't have a question, just a statement. Is that appropriate at this time?
Looking for questions, and then we're going to go into discussion. Questions of the presenters. Representative Cannon.
Thank you, Mr. Chairman. A question for Representative Hill. This is just a clarifying question because I might have misunderstood what you indicated, but I thought that you said that 3% of incarcerated people in Idaho are there on drug offenses, and that didn't seem right to me, so I pulled up the Department of Correction report that says for fiscal year 23 incarcerated population report, of the total incarcerated population, 37% were sentenced on drug charges. Is your 3% a different figure? Did I misunderstand that, or can you speak to that and help clarify that for me?
Mr. Chairman, I'll speak to that. When I did I don't have that data specifically, but I went to the jail, visited the jail, and the sheriff told me that, and that was specific about the actual, just the users were there for just having some using amount. That was the number that came across. It's very low, as all the violence around, all the dealers and all the other thing around it. That was what I received. And I don't have a data point, but that's what I was told by the sheriff when I visited the jail.
And Representative Cannon, as I recall different testimony before the committee, and I'll stand corrected, about 3% had to do with actual trafficking, and there were 37% in drug-related offenses.
Thank you, that's helpful, thank you.
Okay. Representative Handy.
Thank you, Mr. Chairman. Probably Senator Lakey, if I could ask a question.
Mr. Chairman, Representative Handy, certainly.
So as I've weighed this, I think there's injustices on both sides, no matter how you do it. It's not going to be perfect, but as we vote for these things, I'd really, really be thrilled to have some follow-up. Is there anything in place, if this was to pass, that a real effort to keep really good data and see what effects we have in a year as we look at it? Because, I have people tell me all the time that mandatory mandates don't work, but there's no real evidence or no real scientific data out there that shows yes or no.
Mr. Chairman and Representative Handy, so the Department of Correction and law enforcement certainly keep data.
Okay.
And we talked about, for example, I think the data that was presented last time talked about the increase in fentanyl seizures was up 2,600%. From 2020 to 2023. So that seizure data certainly shows that it's exponentially increasing in Idaho. I appreciate the chairman's reminder about 3% on trafficking and 37% on the drug-related clarification. That gels with what I recall. So we can see that it's a growing problem. We can see that what they're being charged with. We can track the results. We can track data on success on probation and recidivism. All those things we do track. One of the things that's a little bit harder to track is the drug dealers that say on their wire, "I'm not doing a deal in Idaho because you guys have mandatory minimum sentences." That's harder to track. That's information that we get from officers on the street that say, "This is my experience in dealing with that." But as far as the numbers of incarceration, the increasing volume, the number of deaths, absolutely we can track all those things. And certainly, I believe that we will have an impact on that. But as Representative Ehart said, we're having an impact. We're not stopping it. We're just trying to make it so they do less business in Idaho.
Representative Cannon.
Thank you, Mr. Chair. For Senator Lakey, do you have data about the percentage of cases that start out charged as trafficking that get pled down by prosecutors to possession or some lesser offense?
Mr. Chairman and Representative Cannon, do I have data? No. Do I know that that happens? Certainly. And, that's, I think, also part of what comes into play with some of those additional facts and circumstances surrounding a particular case. That's what prosecutors are elected to do, and we try to make sure that the system runs as efficiently as we can versus everything going to trial.
All right. Gentlemen, it appears you're done. Thank you for your presentation. I appreciate it very much. You may take your other seats. Now we'll go to discussion.
Thank you, Chairman.
Of the amended substitute motion. Representative Ehart.
Thank you, Mr. Chairman. I suppose somewhat to the amended substitute motion. First, I think it's important that we recognize that for us as a body, as a member of the committee, that we do our job. And the process of going through this, I don't care how long it takes. It's an incredibly important process. And I appreciate the fact that on Friday, you allowed the testimony to go as it did, because we are dealing with people's lives. And so I think it's just important. That's just one thing that I wanted to say. And for us to be willing to do our job, we should never be demonized. And I don't think people necessarily intended to do that. But it's important that we ask questions. If we don't ask questions here, what might we not ask a question in another committee that affects you in a different way? So to you, Mr. Chairman, and our committee, thank you. It's important we do this, stay here. I don't care if it would have taken another day that we do our job. I did try in the summer to engage in conversations concerning this, had people in Idaho Falls specifically affected by this, had a defense attorney friend that could give specific examples, and so that's where some of my engagement had been. This friend also currently represents the FOP, so it's not someone he's well respected. And that's where some of my questions and concerns have come. Also in Idaho Falls, I think it's good to note that we have what we have had for years, what we call community conversations. And so it's been led by a gal who I actually played high school basketball with, but out of BYU, but not through BYU, Idaho. And it's been incredibly helpful, both engaging law enforcement, city council, bringing IDOC in, and people, business people from the community, and then those who've been in prison, sometimes with drugs, sometimes with not, but how do we get them, how do we hear them, their families, how do we get them back into society? Because at some point they're coming back. And how is it that they'll come back? So I just want to say that I wish more had come from that, because I did try. Much of the things that Representative Cannon said, boy, this to you two all the time, I do agree with. And, you know, I probably, as much as anything, also just appreciate that we've, you know, now many have said that we're going to, instead of the fentanyl deaths going like this, you know, hopefully it will go like that. And it's just one of many tools in the toolbox. And I think it's going to be incredibly important, as my seatmate and I have had conversations, that there absolutely is more that we're going to have to do. The people we stop from coming in are the kingpins. The drugs are still coming, but I do believe and hope that we continue to slow it down. I appreciate those who testified. Sheriff Donahue, Gene Fisher, and Grant Lobes were very helpful for me. And I appreciate, Mr. Chairman, that you had allowed us to continue to question Gene Fisher. I think she's probably up there the longest, but it was incredibly helpful. And so I just want to say that. So, you know, probably my largest consternation with all of this, and some of you, we've spoken, it's been helpful. I don't think it's still solved, but as we said, there's probably not a perfect solution on either side. So this is just one of the solutions, but probably it's due process. One person said to me during the summer or fall in conversation with this, he said, but Barbara, look what the judges are doing. Basically meaning we've got judges throughout the United States just letting people off and abusing the power of the judicial system. And that's not what I can control. But the point was well taken. I don't think that's happening in Idaho. However, I recognize that maybe all of us question some of the sentences. I understand that. And so I went forward understanding that which he was sharing with me, and I get it. I think that, you know, in the past, I mean, I think I've stood on the floor 3-4 times now, and I've spoken about our founding fathers. What America has in our due process system is unique. Our judicial system is incredibly unique. It's special. Our founders saw what happened in England and how rule of man is what, I mean, it just changed the rule of man. There's no rule of law. And you know, that our founders thought it was better that a guilty man go free than an innocent man go to prison. So the problem that I see, especially with the vote I'm going to make today, is, you know, and maybe it's the messaging, but everyone wants this. And it's not something just because someone wants it, that's not necessarily how I vote. But let's be honest. It's polled at what, 86% in Idaho? Now, I don't think they have all the information. And so my word out to the people of Idaho is this is why you send us here, to dig into this and to find some of the things that we found and question some of the things that we've questioned. But 86% of the people in Idaho want it. I mean, the people who've been in here to testify for it, family policy wants it, the churches want it, apparently the GOP wants it. At some point, it becomes hard to say no to that. We tried on Wednesday. So, you know, I'm torn because of that. But I will say this. If and as this passes, our prosecutors and our law enforcement, you will have just been invested with more power and more authority And you are being trusted to be wise stewards of it. I'm not always sure that I think that happens, but with the same, that's how it always is. So I would ask that you would all help hold each other accountable. With that, Mr. Chairman, basically what I'm saying is I'm going to support the first motion.
Representative Young.
Thank you, Mr. Chairman. And if I might just make a few comments. I know we're a little long, but I appreciate the process so very much. And I echo what Representative Ehart just said about the value of our responsibility. Members of this committee have been subjected to hints that some out there might run negative ad campaigns against us since as early as October, before we even had bills in front of us, before we had the opportunity to participate in this process and ask these questions. And the pressure that has been brought in regard to this bill has been incredibly intense. I know there are people in the room who are still wondering how I will vote, because I have held my discretion very close to my heart, and I have asked many, many questions, because I feel the responsibility that we hold when we sit in these chairs and we make a vote that changes someone's life. And the tough thing is that there's not a perfect answer. That's the hard thing. And so I think one thing that's really important for people to understand is that this is not a black and white issue. This is not a I'm right and you're wrong, or I'm the angel and you're the devil kind of issue. And I would hope that as we leave this conversation and move forward, that we would show respect for the concerns that have been raised and for the questions that have been asked, and that we would recognize that this is not the end of the conversation. Because as a state, addiction is not going away. Drugs are not going away. This is just one step in a journey, and we need to be able to continue an open conversation about what happens next as we go forward. I'd like to speak just briefly to the mixture language. I have had some of my concerns around that language addressed, and I understand I have received similar answers to those that Senator Lakey has asked as I've talked to our lab people. I want to also be clear that because of the kind of substance that fentanyl is, and because it is toxic in such incredibly small amounts, this substance is different from any of the other drugs that we have mandatory minimums for. With many of the other drugs, we can comfortably say 200 grams of meth is a dealer amount, or 200 grams, of cocaine is a dealer amount. It's much more difficult to say 4 grams of any mixture, and I guess I take a little umbrance when we say 4 grams and then we equate it with 4 grams of pure cocaine, or pure fentanyl, because that's not what we're talking about here. So I think it's legitimate to ask that question and to want it to be resolved. The difficult thing is, as I've talked to my sheriff and lab folks and racked my brain over the past few months, I don't have a better answer. Because everything comes in a mixture. I don't know how to solve the problem. And I see the potential as something that has to be weighed against the benefit. I do believe that mandatory minimums discourage those who actually produce the drugs and the kingpins from coming into the state. That's a good thing. I think it makes it more difficult for them to work their business model. And I think it's a good thing to send a clear message to the people of Idaho and to the teenagers that might plan a party and to everyone else that fentanyl is deadly. And that here in Idaho, we are, to use an earlier analogy, willing to pick up whatever tool we can find in the toolbox to try to put a stop to it. So for that reason, it's my intention to support the first motion. And I guess I have a question, Mr. Chairman, if I may.
Representative Young?
I'm in a quandary if I'm intending to support the first motion as to whether we support, or the third motion. Which one
First one we
is?
vote on will be the amended substitute
Is the
motion.
third motion.
Yes.
So when I would be happy to support either motion, Mr. Chairman. So I suppose I will support the first motion we vote on, and then if we get to the third one, I'll support that as well. So thank you, those of you who have borne with us as we've worked through this process, and I just sincerely respect and appreciate the chance to be a part of it.
Representative Marco Erickson.
Thank you, Mr. Chairman. First of all, I want to tell each member of this committee what a pleasure it is to serve with you and watch the amazing work that takes place every day in this building. I wish you public could see the things we see on this end and the amazing people and the amount of energy and work that goes into this all year long. I mean, I got phone call after phone call, meeting after meeting, community-based meetings with law enforcement, public health districts, national organizations, local organizations. People care about these issues and these topics. And a person like me, if you know me, I work in drug prevention, right? And I've also worked in drug treatment. I serve the people that are affected every day by these kind of issues. So I'm on the front lines. I serve the kids whose parents are struggling with these issues. I get to see all the side effects, all the harm, all the hurt every single day of my life. So I've dedicated my life to preventing people from obtaining substances like this and for wanting them in the first place. So since I came to this building, I've done nothing but put a lot of energy into what I call the inverted V, and that is moving resources as close to the base as possible so we could focus on prevention efforts to stop these kind of things from ever harming our public and the families and destroying the lives of all the people that we see every single day destroyed by these substances, all of them, alcohol included. But fentanyl has taken a really big toll on the families and the people, and sometimes unbeknownst to them, and families who just thought they were doing something that was going to help them feel a little different that day when they were seeking an escape for a mental health problem they were struggling, and then they die from it. You know, it's our obligation to do something, and we don't always know the solutions. They're not always perfect. And so in my world, I think of the scientific things we can do, and the law enforcement piece and this judicial piece is one piece of this beautiful prevention wheel that has so many other components to it. I always say we have to work with the families. We have to do more there. We've got more work to do in prevention with families, with our youth in general, with schools, and investing in the work that goes there. Law enforcement, this piece is very important this day. The policy work, like the little things we can do to make it easier to fix some of these problems. So every time someone comes and says, hey, maybe that's something we could do, we need to be looking at that. So obviously this is not the fix-all to the problem. What are we doing as a community, community-wide interventions, right? And then with our media and the messaging we're sending to the public on these kind of things. So everybody, they're all like little spokes. And this piece is the law enforcement piece that we're really talking about today. It's a very important piece of the pie. And so I'll be supporting the original motion because this piece is very vital to my community and what we do. And I hope that we could continue to have discussions about life-saving pieces, things that we can do for our active users to reduce the likelihood that they are going to have an overdose. The naloxone distribution, some of the things we're doing with policy there, we need to make that in the hands of our public. The suicide prevention efforts we're doing in our state, the mental health support system. We obviously, I'm speaking to not everything that this committee can do, but you guys have showed an interest in that, and I'm very proud of you for that. And thank you for that, and thank you for letting me speak to this powerful issue and that I'm very passionate about. And it's not an easy vote sometimes because we do harm people in this work. I don't want anybody going to prison. I try every day to keep them out of there, to do what I can. But in this case, I'm going to support the work that needs to be done on that one piece of that wheel that's spinning, and that's the law enforcement piece, and they need us to do something today. So that's why I'm speaking to this. Thank you.
Representative Allgood.
Thank you, Mr. Chair. It sounds like we definitely have support for this bill. I would ask that we vote no on Amendment 2 and 3 and vote yes on the original amendment as presented by Representative Roten.
Representative Scott.
Thank you, Mr. Chairman. I just want to say a few things, just because everyone else is sharing their hearts. This has been a hard vote. I do like the fact that law enforcement and the prosecutors are closer to the people than the judges. And I do hope, as some of the comments that Representative Ehart made, that they will use discretion and judgment and still have the tools they need. Government is not going to fix this problem. We are not going to fix this problem by passing this bill. There's a deeper problem of moral decay in our society, and only the churches and the families are going to fix this problem. And I do believe this bill will create some more problems, because instead of us getting calls about fentanyl or drug trafficking, we're going to be getting the calls from the grandparents and the parents whose children are sitting in prison. And those calls are real. Those family members hope for change and want change, and it creates a whole nother set of problems on rehab in our prisons. And so there's so many aspects of this. And then when you tie in what we have dealt with, some obviously since summer, but for the last 2 weeks, I'm embarrassed. I'm embarrassed at some of the things that have happened surrounding this bill. And I'll just leave it at that. And so I just hope that we can be respectful of people where they're at on this issue, know that we are all representing our districts and our people. And the reason I like the amended substitute motion is because what that motion does is it sends it to the floor with no recommendation. And that allows everyone else to just see it without all the drama that we've seen behind it and all the pressure and all. I'm sure they'll be lobbied too, but not to the extent. So I like that. It still sends it to the floor. It's no recommendation. It's saying decide on your own. And so the fact that there's 37 co-sponsors on this bill currently, it's going to pass the floor. So I say just send it out there and be respectful where people are on this. And I would ask the public to not harass people where they are with it. And it is an election year, as we all know, and that's the time where things get ugly. So it's very hard. Anyone that votes against this bill, it will be spun. And so it's just sad that society's like that, but that's where we are. And I would just ask, maybe if each of us hearing this or in this room would do our part to not be those people, I think it'd be a better world.
Representative Alfieri.
Thank you, Mr. Chairman. I guess I'm going to echo some of the things that have already been said, but I'm going to say them anyway. This has been very difficult. This bill has weighed on my conscience because I want to get this right. We all want to get this right. There's been a tremendous amount of work put into this bill from the sponsors and the legislative advisors and everyone on this committee, and the chairman's work has been very good on it as well. And it's been difficult to sit through some of the hearing and listen to some of the things we said. But you know what? We're not going to get this right. It's not going to happen. We can get it as right as we can get it. We're not fixing the problem. We're going to hopefully help alleviate the problem to some extent. And we'll come back and we'll do something else in a year or two on something on drugs because the problem will not go away just because of our legislation. We can hopefully slow down the rise of that hockey stick curve. But we have to get it as right as possible, and I think we've done that. I really do feel that we've done it. We have weighed the issues and been back and forth, I know I have, on many of the concerns about charging youth with homicide over a mistake and things like that. But I think we've vetted it well enough. But I am reminded, as I consider this, of a friend of mine, Frank, who at 17 years old took a pill and died. And I am hopeful that this legislation will prevent that from happening to another family. So I do recommend that we send this to the floor on the original motion and vote with a recommendation to vote for it.
Representative Mathias.
Thank you, Mr. Chairman. I realized this weekend how much of my feelings about this bill are due to an amount of trust that I have in our law enforcement community that I know many of my colleagues do not have and that many of my constituents do not have. And so when we had the initial conversations and we printed this and we read the mandatory piece and there was no requirement of evidence of intention to traffic, that was an extension of trust that I was willing to extend. When we had conversations around trace elements and whatever, I know that is not common. If someone gets pulled over on the interstate with a pound of marijuana, the arresting officer's not going to have reasonable suspicion to test that for fentanyl and go through all the I don't know when that would come up. I was willing to extend trust. We're looking at the drug-induced homicide section, and there was concerns about, well, what if someone is sharing drugs and they don't even know there's fentanyl or anything lethal in it? That should give us pause. I was willing to extend trust. And then on Friday, I heard two things that made me unravel some things that lead me to want to support the substitute motion. When Representative Cannon brought 20-509 to my attention, and I realized that what could be interpreted as a death by sharing statute could be hung via murder charges around a 14-year-old's neck, that gave me pause that hadn't existed. And then when an officer told us that our laws are guidelines, what I heard was that whatever we have in the black letter law, there's going to be a little bit of space around it in which deserved discretion will be exercised. And for that reason, I think sending this to the amending order, which, by the way, when you do it in January, it's a serious bill and you're taking the amendment process seriously. This isn't a March amendment or this is January, this is serious. By taking it to the amending order and bringing more people into the good faith attempts to tailor this, to make it even clearer and more well aligned to the fact that we are really trying to target people who are moving serious weight and making money off our suffering. And I think many of the hypotheticals that have been raised are spurious, but I also think many of the hypotheticals are totally reasonable. And I think that reasonable small amendments could be made to the language here that would reduce that or mitigate against that risk. It would make it clear that mitigating circumstances do matter. And they are important. Mens rea matters. All these things that we know matter. And I think by sending it to the amending order that we give ourselves an attempt or an opportunity to make something. This isn't about right or wrong. This is about, can this be better? And I think the answer is it can. And I think the best way to get there is by taking a trip to the amending order. So I'll be supporting the substitute motion.
Is that a light? Representative Roten.
Mr. Chairman, of course, I support my motion, but, they say, the pursuit of perfection can kill good. And I'm not going to go on and on. We've heard it. And if you haven't done your homework, you should have, right? You should have been talking to your police. You should have been talking to folks. We've had 2 years, 2 sessions anyway. as a parent, grandparent, and I'm thinking all of you most of you anyway, parents or grandparents, you get a kid that's doing wrong, I'd rather get that collect call every week for 5 years from the penitentiary than my kid not doing something wrong and just being a victim of circumstance and get one call from the coroner. It's our chance. We're not going to get it perfect, but we're going to get it good. And we can do it today. Frankly, I think it's our job as a committee when we send something to the floor that we have a recommendation, either as a do pass or fail. I mean, that's our job. That's what we're here for. I just think that either way, frankly, today, if we pass it with no recommendation, we know the people have spoken. Our law enforcement has spoken. I'm lucky to be in Canyon County, I guess, because, man, I love our guys. our blue over there and our judges and courts, I'm lucky over there. But, we're a smaller county than Ada County and some. But, again, as I just sit here and think about what we're talking, we can what if this thing to death. We can send it to amending, and who knows whether it'll ever be seen again. We know what we want to do. We want to get it to the floor. And I think when we send it, it ought to show up properly with a recommendation of due pass.
All right, seeing no further lights, we're going to take a vote, roll call on amended substitute motion that House 406 go to the floor without recommendation. Please turn on your mics for the vote. Representative Sauter, we're going to vote.
Just a clarification question for the chair.
Yes?
Just want to make sure I didn't miss something. I thought it was inferred that, for clarification, if we pass the motion, do pass with no recommendation, is that our last vote on this?
Representative Sauter, yes, that'd be the last vote today, if it passes.
So there's a little bit of brinkmanship here.
Okay.
Representative Mathias, do you have something further as far as the vote? Your light's on.
You told us to turn them on.
Oh, okay.
Right. Just get ready to vote.
All right, I'm bad. Okay. So, everybody understands the motion? Let's go. Okay.
Representative Skog.
Yes.
Representative Scott.
Yes.
Representative Ehart.
No.
Representative Young.
Yes.
Representative Cannon.
Yes.
Representative Erickson.
No.
Representative Alfieri.
Yes.
Representative Allgood.
No.
Representative Dixon, 24.
Yes.
Representative Gallagher.
Yes.
Representative Garner.
Yes.
Representative Handy.
Yes?
Representative Lambert.
Yes.
Representative Sauter.
Yes.
Representative Roten.
Yes?
Representative Gannon.
Yes.
Representative Nash.
No.
Representative Mathias.
No.
Mr. Chairman,
Yes.
I don't know if it's possible to ask to change the vote, given that this is going forward, and I'll look like I voted no when I was intending to support.
If no
I'm
one-
asking to change my vote
No one
then.
has an objection, I would allow you to change your vote. Any objection?
No, I don't object. I'm in the same boat. I would want
Yeah.
to support the motion then.
So Representative Ehart, what do you want your vote to be on this?
Then I'd like to change it to yes.
Okay, so noted.
I would also like to change my vote to yes.
Okay, Representative Marco Erickson, yes vote.
Mr. Chair.
Representative Allgood?
As seems to be moving forward on this vote, I definitely want to be recorded as a yes.
All right, Representative Allgood, so noted if there are no objections. Okay, Madam Clerk. The motion carries 16 aye, 2 nay. The amended substitute motion to send H406 to the floor without recommendation has carried. I appreciate you all. Thank you very much. That concludes our meeting.